7 అయిందమ్మా, కొంచెం 2 minutes వెయిట్ చేస్తామా? కొంచెం people Good evening to all of you. We have finished the Civil Procedure Code in yesterday's lectures. Again, to recap, I'll repeat some of the important provisions which we discussed yesterday. We were dealing with what is called appeals by indigent persons as far as the procedure is prescribed under Order 44 CPC, which says, suppose the pauperism in the lower court is disallowed, then in that case, the pauper whose petition has been dismissed, leave to file the suit as a pauper, can file an appeal under the provisions of Order 44. Then what is the procedure that is followed by the appellate court? As far as the appellate court is concerned, like the inquiry in the lower court, leave to file the appeal as a pauper is filed, then notice is issued to the parties, that is the contesting party as well as the government pleader. And the government pleader and the contesting party is given an opportunity of filing the counter opposing the pauperism petition. Then once the counter is filed, a regular inquiry is conducted by the appellate court to find out whether the findings of the lower court disallowing the pauperism is sustained on sound grounds or not. Then in that case, the appellant who files the appeal as a pauper is examined and also cross-examined by the other side, and also is also cross-examined on every aspect, including cause of action, maintainability, so on and so forth. And the main cross-examination will be directed against the means of the party. But on the strength of the evidence that is led, the inquiry which is conducted, that the evidence which is recorded and the evidence of the other side which is recorded, if the court comes to the conclusion that the person is really a pauper and the lower court has wrongly rejected the pauperism application, then it allows him to to file the appeal as a pauper. Then once the leave is granted, the pauper has got the opportunity of challenging and urging its grounds as far as the appeal is concerned. And once the arguments are heard in respect of the pauperism inquiry, the next step is followed. That is, the appeal is entertained and the appeal is heard threadbare. The records at the lower court is called for, and then the court has got the power either to set aside, confirm, modify, or vary the orders passed by the lower court. Then in that particular case, once the appeal is allowed and pauperism is allowed, the appeal can be argued on the strength of the material that is available on record. Then what happens is, after that, if the court comes to the conclusion that the pauperism has been wrongly disallowed by the lower court, it sends it back to the lower court with the direction, please register the suit and allow him to sue as a pauper. Then in that particular contingency, the whatever inquiry can go on in the suit will go on, subject to evidence, cross-examination, other side being examined, other side being cross-examined, so on and so forth. And based on the evidence on record, if the court comes to the conclusion that the person who has filed the suit has filed it as a pauper and the suit is maintainable and sustainable, then in that case, the suit is decreed, and mostly in pauperism cases, the court also grants the caste. I tell you why. The caste is granted because the government will be watching like a hawk when to get the court fee. Because the government is interested not in the merits of the case, but collection of court fee. And unfortunately, what is happening is most of the courts have become court fee collectors. They want revenue to the government. Then, in that particular case, suppose the plaintiff succeeds, his suit will be decreed with cost. Then, as far as the court fee is concerned, which is payable by the defendant, will be recovered by the government from out of the cost payable to the plaintiff, and that money will be recovered by the government as arrears of land revenue. Then, of course, subject to appeal, so on and so forth. So this is the procedure that is followed under Order 44. The same procedure which is followed by the lower court will also be followed by the appellate court, and thereafter, once there's a direction to register the OP as a suit, regular inquiry goes on. That is what Order 44, which I discussed. Then I also discussed the revision procedure that is provided in the Civil Procedure Code under Order 45. Under Order 45, whenever there's that mostly depends upon the jurisdiction part of it. That is, where the court has exercised jurisdiction, where it does not have jurisdiction, number one. Number two, where the court refuses to entertain jurisdiction, though it is vested with it. And third condition is where there's an error apparent on the face of the record, whether latent or patent. Latent means which is covered, patent means which is visible to the naked eye. Then, in that particular case, if you are able to satisfy the High Court, only please remember, only the High Court has got the power to entertain the revision, not the District Court. Please bear that in mind. Most of the people file revisions before the appellate court. Appellate court has no power. And usually, under the old code, section 115 was there, which is no longer applicable. Today, all revisions have to be filed under Article 227 of the Constitution of India. What does Article 227 says? It says that the High Court has got the right of superintendence over the tribunals below. And whenever an error is brought out and also established, the High Court is not helpless in coming to the rescue of the person who has been uh, victimized by the lower court for no fault of his. Then, in that particular case, the case comes back to the lower court, and then the court has to decide the matter. Here, revision, I also told you that it is not a matter of right, or what is called in Latin ex debito justitiae. Ex debito justitiae means it is not available to you as a matter of right. It is subject to admission by the concerned judge who is entrusted with a hearing matters as far as CRP is concerned. Once you satisfy the High Court that you have got good grounds, you have got a prima facie case or balance of convenience and relative hardship, the High Court admits the appeal. Revision. And along with the revision, sometimes you file a stay petition also. Sometimes stay is also granted where the lower court keeps its hands off as far as the matter is concerned till the revision is heard. I tell you why Article 227 is prescribed is this happened not earlier, and previously when we used to file revisions under Section 115, we used to pay only a court fee of 10 rupees. Justice Subhashan Reddy, who was the erstwhile judge of the Andhra Pradesh High Court, composite Andhra Pradesh High Court, said that parties are getting away with paying a paltry amount towards court fee, and the revenue of the government is getting jeopardized. And he said all revisions have to be filed under Article 227 of the Constitution of India, and this is the same as far as Telangana and Andhra is concerned. So one thing also you must remember that revision is not a continuation of a suit. It's only an incidental proceeding against error of jurisdiction. Excise of jurisdiction not vested with the court, non-excise of jurisdiction though vested in the court, or error apparent on the face of the record, either latent or patent. Only in these three circumstances, revision is permitted. Then the next thing which I referred to was review. Please remember, we pronounce the word as one word. It is not one word. Review. It is not called review. It's called review. Review means when the court has decided the matter, already passed its judgment, but the judgment has got lot of errors which can be detected with the naked eye, and court has not appreciated the contradictions, admissions, and inconsistencies, or wrongly misinterpreted the facts and documents, and also the case law which is cited on the subject. Then, in that particular case, in the same court, you can file a review petition and ask the court to have a relook at the matter. This is what is called review. Review. Review means review. Have a fresh look at the matter. That is called, and it is covered by Article 47, read with Section 114 Civil Procedure Code. Then the next remedy which I discussed also was reference. Whenever there are inconsistent judgments of various courts, and there's a point which has arisen before the lower court, that where the court is not able to decide, it frames the questions and refers it to the High Court for its advisory opinion to answer every question that is raised by the lower court. It is a matter not between the party and the court, but it's a proceeding which is between the lower court and the High Court. And once the questions are answered, either in the affirmative or in the negative, and as per the directions of the High Court on every question, the lower court proceeds in the matter. That is what is called reference. This is very, very rare nowadays. Those days it was there when the judges were really honest enough to say that they are not able to decide on a particular matter. But reference lies whenever complicated questions arise which requires the interpretation by the highest court of the state, then reference is resorted to between the lower court judge and the high court, which has to give its advisory opinion and answer every question that is raised by the lower court. And according to the answers that are given by the High Court, the matter is decided accordingly. These are all the things which I discussed yesterday. Then again, there were some doubts lingering in your mind regarding the provisions of Order 39. Order 39 is the Akshaya Patra as far as civil practitioners are concerned. If you see the civil court, most of the suits that are suits filed for perpetual injunction. As far as perpetual injunction is concerned, it is covered by Section 38 of the Specific Relief Act. What do you mean by injunction? INJUNCTION. Injunction has got different spellings as far as different professionals are concerned. As far as a medical practitioner is concerned, he knows only one thing called injection. INJECTION. And as far as a legal practitioner is concerned, he knows only one thing called injunction. Can't go to an advocate and say, sir, please get me an injection. The advocate simply tells you, sir, I'm not a doctor to give you injection, go to a doctor. And when you go to a doctor and say, sir, please give me an injunction, the doctor says, I do not know what injunction exactly means, go to a court and then take the order. The meaning of injunction means it's a restrictive order, or it's a prohibitory order, it's a preventive order in order to safeguard the interests of a party who has been victimized. Here, it is also, I'll give you an example, sir. Whenever you have an headache, you apply Amrutanjan, Jandu balm or this balm or that balm, Shastri balm or whatever it is. But it does not actually act, but you feel that some burning sensation is there, your headache is going to vanish. And or you have fever, immediately the doctor says take Dolo or paracetamol, or you take Crocin. To some extent, you get some relief. That relief is what is called, to some extent, it is called a preventive relief or a protective relief. And that preventive relief or protective relief, concisely, it is clubbed in one word called injunction. An injunction is laid down in Order 39. Here, whenever a suit is filed for perpetual injunction, it is filed under Order 7, Rule 1, read with Section 26. Beneath it, you say suit for perpetual injunction under Section 38 of the Specific Relief Act 1963. I need not go into the contents, what all you want to say. So, when does an injunction apply? One is when there is an injury or when there is a mischief which is about to be committed, threatened to be committed, apprehended to be committed, or in the process of being committed, then in that case, you can knock at the doors of a civil court and file a suit for perpetual injunction to take a protective relief. That protective relief which you take is what is called injunction. Then injunction is of three to four types. One is called interim injunction, another is called temporary injunction, another is called perpetual injunction, and another is called mandatory injunction. But the principles governing grant of injunctions is no doubt covered by the Specific Relief Act from 37 to 39 of the Specific Relief Act. So first, let me go one by one. What do you mean by ad interim injunction? Ad interim, the word, I think the dictionary meaning of the word interim is for a temporary period, right? Here, when we file a suit, we also file an urgent petition, that is what is called out of order petition, as far as our courts are concerned. And that out of order petition is checked and checked and note is put up by the Sharastada to the allotting judge, and the allotting judge initials it, and if all the formalities have been satisfied, the presiding officer endorses it by saying register the suit. But what are the precautions which has to be taken by the section? The section has to verify the plaint thoroughly, or whether all the petitions have been filed, or all the petitions are in order, whether it is signed by the advocate, whether the wakalat is properly signed, and they are properly attested as per law. Then, along with the civil suit, what are the papers you file? You file the plaint. And I think when I discussed the amendments to Civil Procedure Code under the amended Order 6 Rule 1, all plaints will have to be filed in duplicate. Earlier, before the amendment, we used to file only the original, but now you have to file it in duplicate, and also one copy extra you have to furnish for the purpose of being scanned through the computer, and a permanent record is maintained by the court. And whenever you want certified copies, you are able to get the certified copies because it is stored in the computer. And once a plaint is filed, the out of order is filed, rather, before a court, any court, the endorsement made by the presiding officer is checked and put up. The judge does not hear your matter immediately. Then what happens is he puts his initial and sends it to the section. Then the duty of the section is whenever the bundle is uh, sent to the section has to number it in a register called SR register. SR register means stamp register. Why stamp register, sir? Stamp register, whenever it is entered in the stamp register, whatever scrap of paper you file, whether it is plaint, petitions, affidavit, the the question of documents, and also the stamp which you affix on the plaint, the stamp which you affix on the petition, stamps which you affix on the certified copies of the documents which you file will be entered in the SR register. The advantage of your suit being entered in the suit register is it is prima facie proof that the suit has been filed on a particular day and that so much of stamps has been affixed, and then SR number is given. I think most of you go to the library. In the library books, there's an endorsement. There's a number given to you, accession number as they call it. Accession number means that number that book has been numbered and kept in the register, kept and maintained by the library, and bears a particular number. In the same way, as far as filing a suit and then sending it to the section, and once it is being entered in the SR register, it's prima facie proof that the suit has been filed on a particular day and it has been properly filed. I just give an example, sir. Mostly earlier, now I think you don't have the certificate of posting. Those days, we used to send a notice through registered post as well as by certificate of posting. As far as certificate of posting does not mean service, but it means that the article has been sent by certificate of posting on a on the proper address, you don't get it back. But you say certificate of posting has been sent. In the same way, once your suit is entered in a register called SR register, it's prima facie proof that the papers have been filed. As an advocate, the precaution which you have to take, because most of you are upcoming advocates or senior advocates or advocates of sufficient standing, you have to maintain the suit SR number. Why? Because your client will ask you, sir, whether really you have filed it. Then you can say, this is SR number. And suppose, let us say, you want to trace your bundle, you tell the CMO, sir, this is my SR number, where is my bundle? That's easier to trace the bundle. Then, once all the papers are checked, then the caveat register also is checked. Whether any person has filed a caveat in respect of, they say, in respect of the same subject matter or regarding the same property. And if caveat is filed, the CMO endorses on it, saying that caveat has been filed bearing number so and so, dated so and so, filed by so and so party. And then he places the bundle before the presiding officer who
caveat is filed under what?
148A. 148A.
148.
I discussed it also yesterday. I'll again come to it next. Here, once a caveat has been endorsed, the presiding officer goes through it and then calls the bundle again and sends it back to the section, and the suit is numbered, and the suit again comes on the bench. The court says, sir, I cannot issue any interim orders because a caveat has been filed. Let me hear the other side before arguments are before the orders are passed. Then after that, once the other side files a counter and the documents, or let us say, when you file the out of order, let us say there is no caveat. Then in that case, if the court is satisfied with the facts and the documents, court passes an order, passes an order called ad interim injunction. Ad interim injunction. That means injunction operative for a particular duration of time, subject to notice being issued to the other side, and the other side being given an opportunity of filing the counter and also the documents in support thereof. But interim injunction, please bear that in mind. The judge who grants interim injunction has to give reasons in writing why issuance of notice to the opposite side will frustrate the very purpose of the suit. Only in those special circumstances, injunction can be granted. And once injunction is granted, or let us say ad interim injunction is granted, it is a duty of the advocate for the plaintiff to send the copies of the plaint, copies of the material papers, and copies of the petitions which he has filed into the court by registered post, acknowledgement due to the opposite side, and then file an affidavit before the court under Order 39, Rule 3, saying that he has complied with the mandatory provisions of Order 39, Rule 3, and he files a postal receipt. And once the postal receipt is filed along with the affidavit, it is called complying with the interim orders. Then what happens is the injunction orders, which are the ad interim injunction, which is passed by the court, is communicated to the opposite side along with the material papers. And suppose the interim injunction is granted on 20th of June, again it will be posted to 24th of June or 25th of June. Why? Because the court cannot grant liberal time as far as matter is concerned. Then it is the duty of the other side on 24th or 25th when he comes to file his counter or file his wakalat and then argue the then file, so on and so forth. But one thing is this: suppose the interim injunction is granted only to, let us say, till 30th of June. On 30th of June, automatically the interim injunction comes to an end. On 30th of June, what you have to do is you must file an extension petition of the interim orders and ask the court to extend the interim orders to a further date. Then don't think that you will get a long date. Court will post it after 1 week or 10 days. Then again, let us say on the other day also the counsel does not file the counter, then you can again you have to file a petition for extension of the interim orders. Till such time the other side files counter and his document and spells out his defense, the injunction will be extended from time to time. As far as the civil procedure code is concerned, interim injunction is not defined anywhere or there is no procedure for that, but it is an interim order that is normally granted under the inherent powers of the court under section 151 CPC. And then once the other side files a counter and then the documents, the matter is heard threadbare. And whatever documents are relied upon by the plaintiff and by the defendant has to be marked by the court concerned and give exhibit numbers. Of course, this was not the procedure followed earlier, but the High Court has issued circular saying that whatever documents are filed, please mark those documents. Why? Because the court, while giving its order, has to go through those documents and then give its valued valued orders. Then next is what this is called interim injunction. Interim injunction means injunction for a limited duration of time. But in 1976, I told you that the CPC was amended by Act 46 of 1976, whereby they said, except in extreme cases, ex parte injunctions should not be granted unless you hear the other side because of the principle of adi alteram partem. That means don't condemn a person without giving him adequate opportunity of hearing. And that is the reason why interim injunction is not extended to long durations of time. And once the counter and the documents are filed, arguments on either and the documents which are will be exhibited on either side, and the court commences the hearing in the particular interlocutory. It's called the IA which you file is called interlocutory application. Will be heard by the court, and if the court is satisfied with the averments made in the petition and the documents filed in support thereof covered by facts, then the court allows your petition. That is, the injunction already granted, ad interim injunction already granted, will be made absolute. Or suppose you don't satisfy the court that you have a triable case, then in that case your interim injunction granted earlier would stand dissolved or would stand vacated. Then suppose the defendant succeeds in the injunction application, the interim injunction would be dissolved and the injunction will be vacated and the petition will be dismissed. So suppose we visualize a situation, suppose you are able to satisfy the court as a petitioner I'm talking about, then the injunction becomes absolute. The interim injunction which is granted earlier would be converted into a temporary injunction. Then you can ask me a question, sir, how long this temporary injunction will subsist? The temporary injunction will subsist till the disposal of the suit, not in the middle. But again, once a temporary injunction order is passed or a temporary injunction petition is dismissed by the court, there is a right of appeal or what is called appeals against orders. There is a miscellaneous appeal can be filed under the provisions of Order 43. To quote the correct provision, it is Order 43 1R. Order 43 1 clause R, under which you can file a civil miscellaneous appeal before the appellate court. Please bear one thing in mind. In all interlocutory orders, decree is not normally prepared. What is prepared is what is called a decretal order. And once you file a CMA, you will have to file not only the orders of the lower court, but also the decretal order which is passed by the court. And once a CMA is filed before the superior court, be it the district court or the high court, the first step is the appellate court does is it calls for the records from the lower court and in the meanwhile issues notice to the opposite party, that is the respondent or the respondents against whom the appeal is contested. Then once the notice is issued to the opposite side appears in the court pursuant to the notice which he has received, and he appears either in person or through his advocate or through a recognized agent. And then if he is represented by an advocate, advocate files a document into the court called Wakalatnama. And please remember, if the appeal is filed against the government pleader does not file wakalat, but he files what is called the MOA. That MOA means memo of appearance. Only the government has got the privilege of filing memo of appearance and not wakalat. And once the wakalat is filed, the records of the lower court is sought for, and then the appellate court, which is seized of the matter, goes into the matter threadbare, and arguments are advanced on both sides. And if the court is satisfied that the lower court has committed mistake, then in that case it sets aside the orders of the lower court. And once the appellate court set aside the orders of the lower court, the judgment of the appellate court merges with the lower court, and it will be taken as if the petition has been allowed. The other way around also. Suppose you don't make out a case in the appeal, your appeal is dismissed. So the judgment of the lower court is confirmed. Then in appeal, it's a summary procedure of hearing the appeal. All the provisions of CPC does not apply, but it is only on misappreciation of facts in the interlocutory application an appeal can be heard and decided. Then, of course, if you suppose lose in the CMA or the civil miscellaneous appeal, you can always go to the High Court under Article 227 of the Constitution and file a revision. When does a revision lie, sir? Error of jurisdiction, where jurisdiction is not vested in the court, but court has exercised jurisdiction, or non-exercise of jurisdiction, though vested with the court, and error apparent on the face of the record, latent or patent. These are the three conditions on which revision is maintainable in the High Court. And of course, I told you also it is subject to admission, and you are satisfying the High Court as far as the grounds are concerned. Then it posted for final hearing, and then a matter is heard and disposed of threadbare. Then, sir, we have discussed ad interim injunction and temporary injunction. Temporary injunction is granted under the provisions of Order 39, Rule 1 and 2. Then we go to the next type of injunction. What do you exactly mean by perpetual injunction? Or to put it in simple English, it's permanent injunction. That means once evidences are laid on both sides, facts are also highlighted, documents are also highlighted, evidence also is highlighted, inconsistencies, contradictions, and the case law is also cited. And if the court is satisfied that a case is made out, the temporary injunction gets converted into a perpetual injunction. Please remember the word perpetual means forever. That means for permanent. Then, once a decree is passed for perpetual injunction, it is also subject to appeal under the provisions of Section 96, read with Order 41, Rule 1. Suppose in appeal, the court, suppose you file an appeal, the lower court has disregarded some documents, court has misinterpreted certain facts, it has not taken note of the exhibits that are filed before the court, or it has not taken up the documents which are filed before the court, it has not taken notice of the case law that has been cited, which squarely applies to the facts of the case, then in that particular situation, what the appellate court does is it sets aside the judgment and decree of the lower court. And once the appellate court sets aside the judgment of the lower court, the appellate decree merges with the lower court, and what is executable is only the decree of the appellate court and not the decree of the lower court. Though for execution purposes, you will have to go to the court of the first instance because the appellate court has no execution powers. Please bear it in mind that appellate court has no powers of execution. So once evidences are laid on both sides, arguments are laid on both sides, the facts are appreciated, documents are looked into, case law is looked into, and the court finds fault with the findings of the lower court, the judgment and decree of the lower court is set aside. But please remember, the easiest process for an appellate court is nowadays in the computer language, what we call it is cut and paste. What the appellate court judge does is, he tells the stenographer, Anta kottesara babu, last matram nenu paragraph rasta. Last paragraph, if you see, strenuous arguments have been advanced on both sides, but on a perusal of the judgment and decree passed by the court, I do not find any inconsistencies with the same, and the judgment and decree of the lower court is hereby confirmed. There's a saying, they say, operation successful but patient died. That's what is the judgment of the appellate court these days. Because the appellate court clearly says, sir, why should I dissent from the judgment? If I want to dissent from the judgment, I'll have to give reasons. If I have to give reasons, I will have to burn my midnight oil. If I have to burn my midnight oil, I lose my sleep. Why should I lose my sleep at the cost of my health? This is the attitude of the appellate judges. Please remember, when I started practice, I still remember there are cases which we lose in the lower court, but when we go in appeal, we are wonderful judges who used to reverse the judgments of the lower court. They used to literally do justice to a party. Please remember, those are all golden days. Then after that, suppose you lose in appeal, you have got a right of what is called filing a second appeal before the High Court of the particular state. And second appeals are normally filed under the provisions of Section 100 CPC 100. But please remember, those days, before the Amending Act of 1976, second appeals could be filed as a matter of right. But in 1976, they amended the Section 100 by saying a second appeal lies only on substantial questions of law which requires interpretation by the highest court of the state. But again, begging the questions are, what is substantial questions of law? Substantial questions of law is when a particular case law is cited and it is not properly appreciated by the appellate court, it's called the substantial questions of law. Or number two, when there are conflicting judgments on a particular point by different high courts, which is the high court which the court has to follow. Third one is based on the facts and based on the issues and based on the evidence and record, what are the substantial questions which has to be decided by the High Court exercising its powers under Section 100. And your second appeal, which you have filed in we have filed in the High Court, is not a matter of right, but unless you mention the substantial questions of law, urge it before the High Court, and then argue on that point, it is subject to admission by whichever judge is posted as far as hearing second appeals are concerned. And once it is admitted, the High Court also can grant stay of all further proceedings and post the case for final hearing. And then, as and when the second appeal comes for final hearing, the matter is argued and decided accordingly. Then there was a question asked yesterday or day before, I still remember. Sir, what are substantial? I think that was asked by Mrs. Gauzia Ahmed. What is substantial question of law? Please remember, substantial question of law is you must use your brains. Look into the book, look into the provision. What is that substantial question which you can frame and satisfy the High Court? So, second appeal is not available to you as a matter of right. It's a matter of discretion and subject to admission by the High Court. Again, I also discussed one amendment yesterday, which I forgot, and you reminded me. I discussed 100A. No appeal lies against a money decree where the value of the suit is less than 25,000. So the question is, there is no further appeal as far as amounts less than 25,000 is concerned. And I also said there cannot be a further appeal against a single judge's judgment of the High Court. No LPA. LPA means letters patent appeal. Before the Amending Act of 1976 and the subsequent introduction of 2002 Act, it was available to you as a matter of right. Whenever a single judge of the High Court writes against you, you can go to the division bench by filing a letters patent under 15 of the Letters Patents Act. But now letters patents are no longer available. The only remedy open to you is to go to the Supreme Court of India and agitate your matter. Then we also discussed the various amendments to the CPC. I think now coming to the question posed by one of the person who is attending the Zoom regarding caveat. Caveat is nothing but it was introduced by the Amending Act 46 of 1976. Previously, caveat was not available. Caveat means the party says let not any stay orders be passed, ex parte stay orders be passed without notice to the caveator through his advocate. That means don't pass any ex parte orders of stay without hearing me. Once a caveat is filed, it is a duty of the advocate who files the appeal or any other proceeding to give notice to the opposite side, and no interim orders are passed without hearing the other side. That is what is called caveat. What are the papers you file in caveat, sir? It is only a petition accompanied by an affidavit, and also send the caveat petition copy to the other side by registered post, and then file the postal receipt before the court, and it is entered in a register called the caveat register. And what is the court fee you pay? And also, what is the court fee you pay in respect of a caveat, sir? It is 10 rupees which you pay. and that is paid not under the Court Fees Act but under Rule 295 of the Civil Rules of Practice. All caveats are court fee is paid in respect of caveats under Rule 295 Civil Rules of Practice. All court fees is paid in respect of caveats under Rule 295 Civil Rules of Practice. You do not have any provision in the Court Fees Act which gives you the provision under which court fee is payable in respect of a caveat. Please underline this and make a mention in your book, whatever you are following. Then we go to what is called mandatory injunction. Mandatory injunction means, please remember the word mandatory comes from the word mandate. Mandate means command. Command means order, direct. That is called mandatory. Suppose, let us say, it's a dispute between landlord and tenant. The landlord, in order to get rid of the tenant, disconnects the electricity supply and directs the electricity department to take away the electricity meter. Thereby, the tenant is deprived of the amenity of electricity. Then, in that case, the tenant can file a suit for mandatory injunction against the landlord, asking the landlord to restore the electricity connection and also put back the meter in the same position which it was prior to it being removed. That is, and that order that is passed by the court in the form of a command is what is called mandatory injunction. Here, it also arises. Suppose, let us say, there is a encroachment on a public road. People are prevented from ingress and egress. Or let us say in an agricultural land, sometimes even in Telangana area, all the lands are located side by side. And to enter my land, I have to pass through your land. I have been using it from times immemorial, and he has constructed a wall preventing me from entering my field. I can file a suit for mandatory injunction to direct the other side to remove the wall and allow me free ingress and egress into my property. There you ask for what is called mandatory injunction. I think if you see Telangana, you've got so many festivals which are recognized. For example, now I think the Ashada Masam, that is next month, you get the Bonalu, where the Durga Puja is conducted or celebrated with gay and gaiety. And suppose, let us say, the idol of the goddess is in your field. People have been using that particular way to reach the goddess and perform their pujas and offer their bonalo for years together, for 20 years or so. They acquire a right of easement over your property, though it does not belong to them, but it is a right of ingress and egress. You cannot prevent people from doing it. Suppose you erect a fencing or you erect a compound wall, I can file a suit for mandatory injunction. They have to direct the other side to remove the fencing or remove the compound wall. Suppose, let us say, there is an encroachment as far as your property is concerned. You have given notice to the GHMC asking them to remove the encroachment. Please remember, nowadays GHMC or the local authorities are guided by political considerations or the influence of the opposite side. Then they are not acting on that. Then when they don't act on that, then you are not helpless. You can go to the court, file a suit for mandatory injunction, directing the GHMC to do its duty, what it has omitted to do. So that is where mandatory injunction comes into play. Or I'll visualize a situation. Suppose, let us say, you file a suit for perpetual injunction and obtain an injunction order against the opposite side not to construct at a particular place. But the other side, taking law into his own hands, has erected structures. Or he has opened a window just facing your bedroom. Your right of privacy is affected. Or your easementary rights of light, air, ventilation, sanitation is affected. Then in that case, you can ask the court to direct the opposite side to remove the offending structures by amending your plaint and asking for the additional relief of mandatory injunction also. Why? Because even assuming for a moment you succeed in your suit for perpetual injunction, there is only a paper decree, which is not worth it. That is the reason to get an effective decree. You amend your plaint and then ask for the additional relief of mandatory injunction also. So, as far as perpetual injunction is concerned, it is normally negative in nature. But as far as mandatory injunction is concerned, I'll put it this way: as far as perpetual injunction is concerned, it promotes what is called inactivity. That is, stop your mischief, don't go ahead. That is what a perpetual injunction is. It promotes what is called inactivity. But as far as mandatory injunction is concerned, it promotes activity. What you have omitted to do it at least now. That is what is called mandatory injunction. Mandatory injunction is normally positive in nature, and perpetual injunction is negative in nature. The, please remember all these injunctions, the principles which govern the grant of injunctions is covered by section 37 to 39 of the Specific Relief Act 1963. They are called concisely as preventive reliefs or prohibitive reliefs. Then what are the principles on which injunction is founded? Injunction, I told you the history also, that it was not available in the common law courts. Common law courts, whenever there's a breach of contract, it was only treated as a civil wrong, and the common law courts never used to enforce the positive aspect, that is, to enforce the agreement. And the negative aspect also, preventing the other negative aspect also not to do a particular thing. And it also never used to grant positive reliefs to do a thing which you are omitted to do, right? But the equity courts, I told you, stepped in to fill up the gaps or the defects or the lacuna in the common law and evolved various doctrines. For example, specific performance which was not found in common law or injunctions which was not available in the common law was granted by the equity courts. They are based only on two equitable maxims. One who comes to equity must come with clean hands. There shall not be any concealment, there shall not be any suppression or distortion of facts. All the cards will have to be laid on the table so the other side is given an opportunity of meeting your grievances. You cannot take the other side by surprise. That's why Order 6, Rule 2 says, plead and then prove, not prove and then plead. So that is the reason it is said a temporary injunction or a perpetual injunction promotes inactivity, but a mandatory injunction promotes activity. Then, what are the principles which govern grant of injunctions? We have got three principles. One is called a prima facie case, that means a case triable on the face of it, based on facts, based on documents. Balance of convenience. What do you mean by that? That is the advantage which will be caused to you as a petitioner will outweigh the hardship that will be caused to the other side. And based on the facts and based on the documents, you have got a more triable case than the opponent. That is what is called balance of convenience. Then what do you mean by hardship? In case the preventive order is not granted, then mischief cannot be nipped in the bud. And any amount of money compensation will not be sufficient to undo the wrong which is already in the process. These are the three basic principles on which injunctions are granted. The earliest case law on this aspect is AR 1963 AP 365. There is a classic judgment rendered by the then Chief Justice P. Chandra Reddy and Shesha Chalapati, where they discussed the law of injunctions threadbare and said these three conditions are the conditions which have to be satisfied in order to be entitled for injunction. Of course, this was followed by the Supreme Court in the subsequent judgments also. Then, what are the consequences in case the injunction is violated or disobeyed? That is also provided under Order 39, Rule 2A, which says in case the injunctions are duly communicated to the opposite side violates the order or commits a breach of that order, the court is not helpless. The court can, on a petition being filed under Order 39, Rule 2A, pass an order for imprisonment or for fine and punishing the respondent for disobeying the order. That is Order 39, Rule 2A. These are the topics which I've discussed for the past 3 days. I've been repeating for the past 4 days. But still, people ask, sir, please repeat it. Anyhow, for the benefit of I'm here for your benefit. That's the reason I'm repeating it. At the cost of repetition, I have repeated those provisions. Then the other provision which I also discussed was Order 38, Rule 4 and 5. Previously, under the old code, what do you mean? What is the provision, sir? Attachment before judgment and arrest before judgment. Suppose, let us say, the other side is trying to abscond from the jurisdiction of the court, or he is trying to secrete or transfer or charge his immobile or mobile property in order to frustrate the attempts of the plaintiff recovering his lawful dues, or is deliberately trying to run away from the jurisdiction of the court, and then in that particular case, the plaintiff can ask the court, sir, please attach the movables or immovables property of the respondent pending disposal of the suit. Earlier, I told you, prior to the Amending Act 46 of 1976, whenever I used to ask for attachment, automatically attachment orders used to be granted. But please remember, it also works havoc on the other side, because suppose the claim of mine is only 10,000 rupees, but I attach a property which is worth 10 lakhs. Is it not harassment? Is it not an insult? Is it not causing annoyance to the opposite side? That is the reason in 1976 they amended the act by saying, as far as the provisions of Order 38, Rule 4 and 5 are concerned, attachment cannot be ordered as a matter of right. First is only a conditional attachment can be ordered, whereby the other side is given an opportunity of showing cause why the property should not be attached, and in addition to it, he can be called upon to furnish security for the suit amount and the cost of the suit. Once the notice goes to the other side shows cause and files the counter, and if the attachment petition is not founded on good facts, then in that case, the attachment can be vacated. I just put it in a simple word that to say attachment cannot be ordered as a matter of right. Unless notice is issued to the opposite side, only one thing the court can do is court can grant 3 days time or 4 days time to the opposite side to show cause why his property should not be attached, and then or furnish security for the suit amount and the cost of the suit. And once the security is furnished, or the amount which is claimed by the plaintiff is deposited, the attachment works itself out. What do you exactly mean by the word attachment? Attachment means there is a prohibitory order. Look, your property is subject to the claim of the plaintiff. Don't sell the property, don't alienate the property, don't encumber the property, and the property is a security for the plaintiff to proceed in case he succeeds in the suit. Earlier, attachment orders used to be issued as a matter of course, but after the Amending Act of 1976, attachments are ordered in rarest of the rarest cases, and normally the court orders notice and directs the other side to furnish security for the suit amount as well as the cost of the suit. Unless the court gives an opportunity to the other side and hears the other side, the attachment order is illegal. Then arrest before judgment. Of course, this is a very rare provision which no one fights, because that arrest before judgment, though it is in the statute book, the court does not enforce it. Then I discussed one more provision called summary suits. I also gave the I also gave the history of summary suits. Summary suits in Telugu, I think మీకు తెలుసు అనుకుంటా. వచ్చే కొట్టే తెచ్చే. That means elaborate inquiry is not required. Here, suits based on negotiable instruments, suits based on non-contentious issues, suits based on not much of contest, but it can be disposed of immediately, or elaborate trial is not necessary. They are all called summary suits. Earlier, prior to the 1976 amendment of CPC, Order 37 was only applicable to the presidency towns, that is Madras, Bombay, and Kolkata. But 1976 amendment brought about the change whereby they said Order 37 also applies to provincial towns. That's how it is now applied to all the cities in all the states in the country. What is a summary suit? Where it is based on a negotiable instrument. It's begging the question, what is a negotiable instrument? How many types of negotiable instruments are there? One is called a promissory note, another is called a bill of exchange, and another is called a check. What is the provision which defines a promissory note, bill of exchange, and check? It is Section 4 of the NI Act which defines that. Promissory note is on demand or order, the promisor promises to pay a particular sum of money to the promisee or his nominee or his agent, which is the amount borrowed towards hand loan. Then he signs on a revenue stamp, and promissory note is executed. But the printed forms which are available in the market, you have another, on the other side, you have got a receipt. Receipt also bears a date, and there the promisor says, I so and so hereby hereby admit and acknowledge that I have received a sum of rupees so and so towards hand loan from Mr. So and so, resident of so and so. So he signs it on the revenue stamp. Then what do you mean by that, sir? It means first he has received the money, executed the receipt. That is who promisor, that is the debtor. And after having received the money, he promises to repay the money by executing the promissory note. But please remember, printed forms are sometimes misleading. If you see a printed promissory note carefully, down you have got a column called security. Some other third person says, in case A does not pay, I will pay the money. And he guarantees the payment. He signs the security column. Please remember, once the security column is filled in a promissory note, it becomes a bond, a guarantee. Once it becomes a guarantee, it has to be stamped like a guarantee, not like a promissory note. So better don't rely on the printed form. Try to type it out so that no mistakes are committed. And please remember, an unstamped receipt can always be validated by paying the duty and penalty. But as far as an unstamped promissory note is concerned, it's a nullity. It cannot be enforced. An unstamped promissory note is not admissible in evidence and cannot be relied upon in a suit. Then the bankers use the term called demand promissory note. If you see the banker's document, it will be only one sheet. There will be no receipt on that. First, what happens is the borrower executes the promissory note in favor, executes the demand promissory note, or what is called DP note, in favor of the guarantor for that particular sum of money. Then the guarantor on the reverse of it, I so and so, having as a guarantor, do pay hand over this promissory note to SBI or Union Bank or whichever it is. Then he puts his signature and then puts a date. What do you mean by it? First, the borrower is responsible to the guarantor, and borrower and guarantor both put together are jointly and severally liable to the assignee. That is the person in whose favor the promissory note has been negotiated or transferred. That is the sanctity of a demand promissory note which the bankers normally maintain. They don't have a receipt. It's not a pro forma like a promissory note and receipt. It's only called a DP note or demand promissory note. Please bear one thing in mind, that there is another type of NI, negotiable instrument called bill of exchange. This was mostly prevalent during the mostly the Sindhis used to use it. There are three parties in the drawer, drawee, as well as the payee. The drawer has some arrangements with the bank, and whenever this bill of exchange is presented to the bank for payment through the OD facility that is granted to the customer, the amount is paid to the borrower, and then the creditor can bring a suit based on the bill of exchange. But of course, bill of exchange is no longer existing. Very, very rare cases you come across bill of exchange. In a bill, the only difference is in a promissory note, there are two parties, one called the promisor and the promisee. As far as the bill of exchange is concerned, there are three parties called drawer, drawee, and payee. Then we come to the third type of NI called check. I think most of you are financially well off. Most of us operate through banks. You have got the checkbook which is issued by the bank in respect of the account which you hold in the particular financial institution. In a check, how many parties are there? So there are three parties. One called the drawer, another called the drawee, and another called the payee. And normally the check is issued in the name of the, in the on the name of the bank in favor of a particular person for a particular sum of money with a particular date, and on presentment, the check has to be honored by the financial institution, that is the payee. And of course, if the check fails and all, what all takes place, you know. As far as a negotiable instrument is concerned, when a check gets bounced due to some reason, you can always file a summary suit and to direct the other side to expedite the matter and make the payment. Of course, it's an offense also, you know, under section 138 to 142 of the NI Act. Then you have got what is called non-contentious matters. Suppose, let us say, the relationship of landlord and tenant is there, and the tenant is due arrears of rent, and the amount, the quantum of rent is admitted, the arrears also is admitted. Where is the question of going for a regular suit? Straight away, you can file a summary suit. And so, straight away, you can file a summary suit, and the procedure is when you file a summary suit, summons are issued to the other side, and the other side appears pursuant to the summons either by himself or through his advocate or through his agent, and then gives a notice to the opposite side. Sir, I have already entered appearance in this case. Please serve all the papers on me since I am the advocate for my client, that is the defendant. And within 10 days, the plaintiff's advocate has to serve on the other side the summons for judgment. Then the other side, within 10 days on receiving the summons for judgment, has to file an application before the court to leave to defend. That means he says that I've got a triable case, I've got a valuable defense. Please permit me to defend the case. Then once the other side files a counter, the matter is heard. And then once the matter is heard, it is disposed of, leave is granted or leave is not granted. And once leave is not granted, an appeal can be filed. When leave is granted, also appeal can be filed. That is a procedure that is followed. But please bear one thing in mind, that sometimes summary suits are dangerous also. Why? Because like a hawk, you must be watching from the in the section whether the summons have been duly served on the other side or not. Why? Because the time schedule that is given under Order 37, you have to adhere to it in the strict form. If you don't look into it, it becomes an ordinary suit. It's no longer a summary suit. Suppose, let us say, leave to defend has not been filed, straight away the court, without going into an inquiry, going into the evidence, can straight away decree the suit. Those are the consequences of summary suit that is under Order 37. Madam. So these are the topics which I wanted to revise, which I revised. I think the host also reminded you yesterday the balance of civil procedure code. But please remember there is no balance left. But still, for the benefit of those of you who have not attended the earlier lectures, I repeated it. And again, only thing is I'll wind up by giving you some important provisions of civil rules of practice. The first rule is Rule 28. Whenever you file an amendment petition or whenever you file a petition to bring persons on record, you have to mention the consequential amendments also which you have to make in the plaint or the written statement. If you don't mention it, court will not permit you to file a separate petition to carry out consequential amendment. That is Rule 28. Then next one which I discussed was Rule 201. Whenever a copy application is Nokia, please. Whenever a copy application is filed and the copying charges are not paid and your CA is struck off for non-payment of charges, you don't file a wild CA, but what you file is you file a restoration petition under Rule 201 Civil Rules of Practice, asking the superior court, that is the district court, to allow your petition and permit you to pay the copying charges. The advantage what you get is your CA will be restored and you get the benefit of the limitation. Then another provision which I discussed was Rule 232 to 234, which is popularly called check petitions. Check petitions are normally filed in the form of a petition and affidavit accompanied by a receipt, duly stamped, and along with a printed form of what is called memo of part satisfaction or memo of full satisfaction. And the procedure is whenever a check is granted, check will not be granted in the name of the advocate, but to be granted in the name of the party because these are according to the guidelines of the Supreme Court. Earlier, in most of the compensation cases, the money never used to reach the party, and because the check used to be granted in the name of the advocate. The Supreme Court laid down saying that the practice of issuing a check in the name of the advocate should cease, and the party who has to get the check will have to give his passbook, his or her or their passbook to the court, and straight away the amount is credited to your account in whichever bank you have got an account. And normally, to safeguard your interest, what the advocates do is they take a promissory note or they take an agreement that so much of percentage of fees will be paid in case you get the check. These are the, and I also told you 295. When you file a caveat, the court fee is paid under the provisions of Rule 295, Civil Rules of Practice. Then I also discussed Rule 125 to 127. There they say, suppose the copies of the plate, copies of the petition, and copies of the material papers are not served on you, you need not beg the other side. Straight away, you can file a memo under Rule 125 before the court. Say, I have not received the papers. Please direct the other side to furnish the papers. Then, under Rule 126, the court passes an order giving a direction to the opposite side to furnish the documents and furnish the material papers. Suppose, even pursuant to that, also the copies are not furnished, the court can act under Rule 127 and reject the documents and even reject your plaint in certain circumstances. That is Rule 125 to 127. These are only the important provisions of what is called civil rules of practice. Then you have also got Form 61, which deals with BATA or which deals with process. Then you have got BATA means notice to the other side. Then you have got what is called summons for settlement of issues. That is under Order 5. That's also there is one rule there in the civil rules of practice. Then if it is for an interim or it is for in a notice to the other side to show cause why order should not be passed, it is show cause notice general. And suppose you want to issue notice to the other side why execution should not be issued, you've got printed forms for that. That is also contained in the civil rules of practice. And suppose in appeal you want the other side to appear, you have got what is called a form called notice of the date, notice to the respondent for the date fixed in appeal. Then suppose you want to give notice to the other side to produce documents. There's a particular rule provided for that. You can always give a notice under that particular rule. So like that, you've got many rules. I only highlighted the important rules of civil rules of practice, which you have to bear it in mind. I think it's not possible for me to revise mortgages and other suits. When we come to the end of the lectures, in the end, I shall try to only revise some important orders which has to be borne in mind. Thank you very much. Now the interaction time starts.
Sir, good evening, sir.
Good evening. Yes, please proceed.
Sir, what is affirmation? Sir, affirmation.
Pardon?
Affirmation, sir. What is
Affirmation. 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 Affirmation means verifying and testifying the affirming or accepting the averments which you have made in the written form is called affirmation. It is quite contrary to oath. Oath at the pramanam తీసుకోవడం. That is only in Hindus. But as far as Muslims are concerned, they don't take oath because it is against the Shariat or their personal laws. A Muslim only affirms to the facts. He testifies to the facts, saying that the facts mentioned above are true and correct. That's why it's called affirmed. Use the word affirmed and signed. But as far as Hindus are concerned, we say sworn and signed before me. Am I making myself clear to you, please? Then I'll also answer a question before you ask the other question. Affidavit is defined as where it's a sworn statement of facts made on oath, or it's an affirmation of facts which are signed and testified to, by the affirmant, as far as Muslims are concerned.
Sir, the checks are when the promissory note is connected with the check. not only promissory note, it is connected with the check. Then it comes under as a
Then
security or what?
it is
Promissory note is given by the check.
see,
along
as
with the
far as
check.
promissory note is concerned, the primary document. As far as the check is concerned, pursuant to the promissory note, a check has been given. So the question is, a promissory note and check goes together. Promissory note is given in proof of having received the money and promised to make the payment. But PDCs, as they call it, post-dated checks, checks which are there, are given. For example, if you go to hire for hire purchase, Bajaj Electronics, it says you can pay 1 rupee and take the article. But they take 48 PDCs from you, post-dated checks from you, whereby they say every month when the check is presented for payment, you must provide sufficient funds to see that the payment is honored. Yes?
This, my name is Ram.
Yeah, I have to ask one more question.
Yes, please.
I am Muralidhar Bala, retired student of police.
Yes, sir.
After retirement, I joined, enrolled as advocate.
From Telangana Police? Telangana Police?
Telangana Police. I was SP Vigilance Hyderabad.
When Mr. Gopinath Reddy was there, Anjaneya Reddy
Yeah,
was there.
everybody.
Yes.
I
Because I was
inspired.
in the police academy also. That's why I know that.
Police academy. Yeah, I was CA in various police stations,
Yes.
University, Begum Bazar, Afzalganj.
What's your good
Task
name?
force.
What's your good name, sir?
Muralidhar
Yeah,
Bala.
please carry on.
So actually that day, I'm okay. You know that as far as criminal cases, no much problem for me. I'm trying to learn about the CPC, which is a vast subject.
Yes, sir.
After retirement only I started doing. Now
Yes.
I filed a NI cases. I am for the respondent.
Right.
So 25 lakhs is the 3 checks they have given.
Right.
I have filed a discharge petition under 245
Right.
and argued.
Right.
Of course, the other side were telling that it's a summary trial case where it's not a warrant case, it's only summons case.
Right. STC.
STC.
Right.
So, what my point is that the NI Act main provisions, provisions of a mandatory as the notice was not properly served to the 2 accused out of 3.
Right.
So, that is a mandatory.
Right.
Provision, I was arguing on that.
Right.
And also on 141 of the NI Act.
Not 141,
Cause
142.
142. Cause
Yes.
of action starts after 1 month.
Right.
It has to be filed within a 1 month. With the
Right.
court.
You're right.
Other side filed the case 1.5 months.
Pardon?
45 days.
So that is
45 days.
the barred by limitation.
Limitation. That's I was arguing. On these points, of course, he was arguing only for the warrant case and he was telling that only 482 you can go and
482 you cannot go to the sessions court. Only High Court has got the power.
High Court. You were telling.
Yeah.
Not this court has powers to discharge the case in a warrant.
Right.
STC case.
Yes.
I was arguing that the provisions of the main it has to be followed.
Now one more provision is there, 142, which speaks about a recoverable debt. That is, there must be a pre-existing monetary liability, and the check must have been given to honor that pre-existing liability, and the check should have got bounced when presented for payment. Only in those circumstances an offence is made out under 138. And now there's a provision also provided. There they say interim compensation also can be ordered. If I'm correct, it is section 148 or 149 of the NI Act. Yes. So you must have argued on pre-existing monetary liability.
Yes. Now my point was another 2. 3 accused are there. Only 1 accused is served. Other 2 accused were also joint signatories, not served.
Then you'll have to go to the High Court by filing a criminal petition for discharge under 482.
No. Okay. Yeah, I understand. But what my point is, summons cases, in STC cases 258,
it does not apply.
It says, no, it's 258 where courts can stop the proceedings.
But discharge cannot be ordered.
And that also comes under discharge, it says under 258.
But courts are reluctant to exercise it.
My point is why the main provisions of the compulsory provisions of the Act not followed by the
Act is not followed అంటే వాడు చదవడండి, మీరు ఎన్లైటన్ చేయాలా, అండ్ ఎన్లైటన్ చేసినా కూడా వాడు బుర్రకి ఎక్కాలా, వాడు బుర్రకి ఎక్కినా కూడా వాడు రైటింగ్లో వేయాలా, అంత కెపాసిటీ లేదండి. డోంట్ అట్రిబ్యూట్ wisdom to people who do not have that.
That's what I'm arguing on the point to discharge, stop the proceedings. Okay, 482 is there.
That's a triable point which can be tried. Even if you don't succeed here, you can always go to the High Court by filing a criminal petition.
Revision if I go to the Sessions Court?
You can go, but one thing, discharge will not be decided by the Sessions Court. You'll have to go
Oh,
only to the inherent powers of the Criminal Court under 482. Yes. Being a
So you
police
said,
being a police official, you must be knowing it better.
no, I'm just right.
Right,
So
sir.
that will be good. There also they can
Right,
hear and
right,
all that.
Mr. Muralidharan.
Thank you.
Yes, next, please.
You said this in CPC, district courts are they are not appellate courts. Essentially, what's it? Only High Court is. But revision and all that.
No,
in
revision does
criminal
not
cases,
lie to the district court. Only High Court has got powers under Article 227. The right of superintendence is only given to the High Court, not to the district courts.
the 397 CRPC now on
No,
criminal
see,
cases.
No, criminal
revision
cases,
can-
revision you can file before the Sessions Court. But if you want to invoke the inherent powers of a criminal court, only 482, you have to go to the High Court, not to the district court. But of course, I think I still remember if you are in service, Justice Radha Rani was the Metropolitan Session Judge. She used
Yes.
to number even appeals against acquittals before the Sessions Court. The High Court found fault with it, saying that appeals against acquittals, the Sessions Court is not empowered, it's only the High Court. And that too subject to leave granted by the High Court to file an appeal against acquittal. Conviction is a matter of right, but acquittal, leave has to be granted to file an appeal. And the prosecutor will have to be heard. That's a fit case for an appeal to be entertained.
Thank you, sir. So you're doing a lot of service to the taxpayers.
Thank you very much, sir. I'm obliged. Mr. Vasantrao,
Good evening, sir.
good evening.
Sir, it is not concerned to this CPC, sir. I have one another doubt regarding the partition suit, sir.
Yes, it's also concerned with the civil suit only. Tell me.
Civil suit, sir.
Yeah.
Sir, partition suit was filed way back in the 2000, way back before 2000.
Right.
The market value of the properties only 50,000 in those days. And now the suit was decreed and the final decree was going to pass.
Hmm.
And I have asked to file the stamp paper.
Yes.
Now the property value was increased variously.
Right.
Now I have to submit the stamp paper on the date of the filing of the partition suit.
Normally, it dates
present
back,
market
it
value.
dates back to the date of suit, but as far as registration is concerned, it is as per the market value prevalent in the book records, books maintained by the registrar.
Yeah, the present market value.
Yeah,
I have to submit.
exactly.
Only have to engross the.
No, you'll have to pay the stamps, and it's engrossed on the stamp paper. And under Section 18, registration of a final decree is only optional. But if you get it registered, it's a document of title for you.
It is as far as my knowledge, the final decree is not necessary for registration. Only final decree is engrossed on the stamp papers.
It is engrossed on the stamp paper, but under Section 18, it's optional. You can get it registered also.
It is optional, but not necessary.
Not necessary, not mandatory.
Not mandatory.
Not mandatory.
How much stamps I have to submit?
That is according to your share. Whatever share you are entitled, the share value you have to pay.
At the time of market, the present market value, or the time of
Present market value, sir.
I have to file present market value.
Exactly.
Welcome. Thanks, sir.
Sir, is there any provision of law for filing memo?
There is no provision, sir. We file a memo as a matter of course to bring the facts to the notice of the court. CPC does not give any provision regarding memo, sir. Memo is only for the knowledge of the court, or bringing it to the knowledge of the court. We file a memo. There is no provision in CPC.
It is a communication between an
That's all.
advocate and
Exactly.
I was been asked by a junior civil judge
Yeah.
to give the provision of law for filing memo,
I'm sorry,
saying
sir.
that both plaintiff and defendant has settled the matter out of the court. So let there be a stoppage to the proceeding of the courts. Hence, the court may dismiss as withdrawn. I filed a memo. The court said, "What is the provision of law to file the memo?" And I was banging around the books yesterday, so I could not come.
There is no provision for memo, sir. If you want any encounter any difficulty, You try to ask the court to refer it to Lok Adalat. You can get that memo recorded there.
I have suggested the court the same, but court has insisted to file.
There is
to
no
give me the provision of law.
there is no provision as far as provision of law as far as memo is concerned, sir. Unfortunately, thanks to the Supreme Court, which says even without any standing in the profession, a person can become a judicial officer.
Yes, sir. Thank you, sir.
Sir, namaste.
Low battery. Huh? Yes, sir.
Sir, namaste.
Gupta.
Sir, namaste.
Chappan.
Sir, plate 5 years after, sir. Next, other side will file the written statement.
Yes.
Then again, the plate is made by defender.
See, sir, one thing is the steps are like this. Once a plaint is filed into the court, it is checked and numbered. And once it is checked and numbered, the next step comes order 5. Summons are sent to the other side by under order 5. That is personal service, summons through court, summons through registered post, and substituted service in case it's avoided. But by the amendment of 2002, now speedier mode of service of summons has been provided. You can send it by courier, you can send it by speed post, you can send it by EMS, you can send it by email, or you can send it by any other quicker mode of service. But one condition is you will have to file the proof of service, that is, file the tracking report. That is the second stage. The third stage is the party appears pursuant to the summons under order 3. That is, he appears in person or through an advocate. And under order 4, the advocate enters appearance by filing a document called Wakalatnama. And after that, the next step comes, that is filing of written statement under order 8, rule 1, within 30 days from the date of receipt of summons. And or in the alternative, if 30 days is not sufficient, 8.2 says if the court has got power to extend up to 90 days. But the judgment of the Supreme Court on this point is that as far as the 90 days period is concerned, it is not mandatory, it's only obligatory, except in the case of commercial courts. The judgment is 2004-5 Supreme Court cases, where the Supreme Court says that even the 90 days period can be extended if the other side can be compensated by cost. Then the next stage comes, that is what is called issues. What are the points on which the parties are differing? The points for determination will be determined, and they are called issues. After that, time of 3 weeks or 4 weeks is granted to file the documents and also the list of witnesses. Then after that, the next stage is reached, where even after the suit is, suppose at the time of suit you have not filed the documents, later on you can file the documents. If you are the plaintiff, it is order 7, rule 14 bracket 2, and if you are the defendant, it is order 8, rule 1A, where the documents can be filed by the defendant. And the earlier provision, order 13, rule 2, under the old code is no longer applicable. Then we come to the next stage, issuing summons to the witnesses, that is order 16. I summons to the witnesses to give evidence or to produce documents. Then we come to the next stage, that is what is called filing what is called evidences in chief. Earlier, the courts used to record the chief examination. Now we can file an affidavit regarding that fact, and the documents which are there will be marked by the court, and then the matter is cross-examination is conducted by the court itself or delegated to an advocate commissioner who records the cross-examination. Then after that, the next stage is reached, whereby the court proceeds in the matter, hears the matter, limits the time, and also directs the parties to file written arguments. That is under the provisions of order 18, rule 2, bracket 3. And once the written arguments are filed, the other side also is given 7 days time to file the written arguments. Then after that, the court proceeds under order 20, passing a judgment. And within 7 days from the date of judgment, it prepares a decree, because the 7 days is for the parties to file the memo of cost and fee certificate. And after that, the decree is drawn up and the judgment and copy is given to you, where you apply for a copy. Then we come to the incidental proceedings also. Suppose during the course of the proceedings, either the plaintiff dies or the defendant dies, or a 22 rule 3 and rule 4 are there, where you can bring the LRs and record. If you don't bring them on record on time, that is 90 days period, you got Order 22, Rule 9, where you can file a petition for setting aside the abatement. Then after that, even after that 60 days is over, you don't bring the LRs on record, then you got Section 5 of the Limitation Act, where you can ask the delay to be condoned. Then after that, you've got other proceedings also. You can get a commissioner appointed. You can get the evidence recorded to a commissioner, or you can make an application for local inspection of the property, or you can make an application for appointment of commissioner to take an inventory, or you can get a commissioner appointed for partition of the property and dividing the property, or you can get a commissioner appointed for the purpose of ascertainment of mean profits, or you can get a commissioner appointed for sale of the property, or you can get a commissioner appointed under the SARFAESI Act, that is the commissioner to go along with the bank officials and the police authorities and take possession of the property and record the possession and report to the court. All these proceedings are there subject to final decree being passed. In this regard, I would like to remind you, any number of, even partition suits also advocates are appointed. The commissioners are appointed for division of property. But one thing, please bear it in, there is a ruling called AR 1967 Supreme Court, which says that any number of preliminary decrees can be passed if a person who is a proper and necessary party to the suit who has not been impleaded, he can come with an application to set aside the preliminary decree and to get a hearing from the court. These are all the consequences which are there, sir. And ultimately, we come to the appellate procedure, that is under Order 41 if it's against decree, and miscellaneous appeals, that is under Order 43. Then revision if it is under Order 45. Then review under Order 47. All these provisions are there. But ultimately, when you want to reap the fruits of the decree which you have obtained, your client is interested only to file the decree copy, and through the decree only you get it executed. Judgment is of no consequence as far as executing decrees are concerned. These are the various stages in a civil suit, please. One by one, you have to go through. Am I making myself clear to you, please?
Yes, sir, 100% clear.
Yes, I've already discussed. That's the reason I went with this particular speed, please.
Superfluous, sir. But my question is, there is circumstances if we appear to reply the statement.
You are asking about rejoinder.
Yeah, right.
Rejoinder is what is called additional pleadings. That comes under Order 8, Rule 9 CPC. Rejoinder is not available to you as a matter of right. If there are any contradictions which you have to answer, clarifications which you have to give by way of a further reply, it is called a rejoinder. And rejoinder, whenever you file it to the court, you must take the permission of the court under Rule 6 bracket A, permission to file rejoinder. Rejoinder is nothing but reply to the written statement.
Even IA also says that, sir.
Pardon?
Even IA.
Even in IA, suppose counter affidavit is filed, you have the right of filing. It is not called rejoinder, but it's called reply affidavit.
Thank you, sir.
Right.
IS are filed with what is the stamp duty, sir?
Affidavit only 2 rupees, sir. IS are only 2 rupees.
Court fee.
Yes, sir.
No court fee, sir.
2 rupees.
2 rupees.
Yeah.
Sir, can you explain about
Affidavit.
documents in a civil suits, CPC, and documents in a criminal case?
Sir, documents in a civil case are the documents which are called suit documents, which is the foundation of your claim made in a civil court, isn't it? But as far as the documents filed in a criminal court is concerned, it is normally filed by the prosecution. That is comprises of the complaint, the FIR, the documents which the police gathered during investigation, the 161 and 162 statements or the 164 statements, the Panchanama, the statements of eyewitnesses, or the inquest that is done, the autopsy which is done. All those things form part and parcel of the documents in criminal cases. Or I go still further. You take the case of Kavita. In the case of Kavita under the PMLA Act, some documents were seized, some properties were searched, some properties were recovered, some incriminating prompts, etc. was recovered. All those things are supposed to be documents which support the prosecution. They are the documents in a criminal case. Vivo.
Yeah, so now criminal, if you see now recent new BNSS, where it says that bail can be taken a part bail. Now we are supposed to take bail, apply, take a police custody within first 50 days. Now
14
it
days.
says partly.
Yes.
That means it can be taken later also. Now that was the problem for arresting delay. Now
Yes.
they can delay it and produce for the court.
Within 24
Not
hours.
for the police custody after 50 days or 1 month. Whenever bail petition is moved, they can
No,
say that,
as far as ordinary criminal cases are concerned, first the remand is done if the police ask for it for a 14 days period. But it's extended from time to time, not later than 30 days. But all cases under the ED or the PMLA, the maximum period for which remand can be extended is 6 months.
not remand. I'm talking about the police remand custody of the
Custody of the accused. Custody of the accused, either police custody or judicial custody. Judicial custody is normally ordered, but as far as police custody is concerned, if a person is required for interrogation, then police custody is ordered in very, very rare cases. But in PMLA, police custody is normally granted. You take the case of Mr. Kejriwal, recent judgment of the High Court, which says that the bail was cancelled, and they said they have extended it up to 29, where on police custody he can be interrogated. 3 days custody was granted. Even in NDPS, sir, even in NDPS cases, also the 6 months period remand can always be ordered, sir. Previously, our understanding is only remand can be only for 90 days. No. There, even if the charge sheet is not filed, police can get it extended from time to time for a maximum period of 6 months.
My point is now new act which is going to come.
Yes.
Not till now, first 50 days of the remand you have to ask for the police custody.
Right.
Now it says partly it can be asked later also, not only first 50 days.
That of course the new act did not come into force, but
it is going to come.
It is going to come from 1st July. But I got my own doubts because it may be deferred. Because the reason is the act which has come into force was passed during the absence of 146 MPs who were disqualified. They did not participate in the discussion. I'm not talking from Congress point of view, please. But the question is that it's any act, let it be BJP or let it be Congress. But the question is it's subject to discussion in the houses of parliament. And another thing is subject to amendments also and discussion. But it has been passed in a hurry, no doubt. The new acts are there, but we are not able to pronounce it also properly.
Now the point is, it has taken a generation of time, everybody to understand whether till now. I don't know these new acts. Take another generation. By the time life will be over.
In fact, I was proceeding to write a book on CRPC. I stopped it midway because the new act is coming. I'm comparing the old act and the new act, and also criticizing in what respects the new act is defective. Because that is why it is said, Abraham Lincoln said, an advocate revels in the exception rather than the rule. Right? And your culpable homicide, which was murder, was in 302. Now it has become 102 into the new act.
Yes. And
terrorist offences are made more stringent. I think I heard a lecture today of one of the franchises who distinguished between a crime and an offence. He said a crime is not punishable. A crime, suppose a social crime. A beggar comes to your house and asks for alms. You enjoy yourself lavishly, and the beggar says, "Sir, I'm starving for 1 week. Please give me some food so that I can eat and live." But you chase him away, and within the next day he passes away. No doubt it is not an offense. It's only a social crime.